We are live. Welcome to the Black Women Lawyers Presents the People's Law School Virtual Edition. We're glad to have you here. I have two awesome attorneys here to answer any questions you may have regarding family law and probate law. We have attorney Gwendolyn Davis Yancey and attorney Tanisha M. Davis. Gwen, could you please introduce yourself?
Hi, everyone. I'm excited about being part of this. I am Gwen Davis Yancey. I'm a family law and estates and trust attorney. Been practicing over 25 years. And with family law, I was mainly focusing in on custody and parenting time issues, whether it was involved in paternity cases, divorce cases, or straight custody cases. And estates and trusts, I prepared trust binders, and which include all the trust documents, because it's really, really important for people to not only prepare for their wealth as they're living, but to also prepare and develop generational wealth. So I'm excited to be here.
Thank you, Gwen. Tanisha, can you please introduce yourself?
Yes, I'm also very excited to be here. My name is Tanisha Davis. I have been a family law attorney for the past 12 years on my own practice. Started out doing a lot of criminal law, working with some very great criminal attorneys, and then kind of shifted into family law. Part of my practice primarily deals with very complex custody issues, high, asset divorce cases, as well as a very, very important focus on representing dads. I am also the founder and CEO of a mobile app platform called Kounsel Konnect, which I'm very excited, which kind of helps solo and small firm attorneys handle scheduling conflicts. And I am very excited to be here and excited to answer any questions you all may have.
That's awesome. I'm attorney Chandrika Simmons, also known as the Law Chick. I have a small boutique practice here in Oakland County. I practice civil litigation, labor and employment law, family law, probate law, contractual law. I will sue anybody. So that's what we do here, and I'm glad to be here to answer any questions you have regarding family and probate law. And I hope we can answer a few questions today. Anybody have an overview of how they have been handling their fielding questions from their clients during this time? Gwen?
Well, I actually have been doing some Zoom conferences with my clients, even though I can meet them in my office, but I've chosen to do Zoom conferences, especially when I'm meeting the client for the first time, or when we're going over, important documentation or things like that. And of course, I still talk to clients over the phone, but I have not met a client in the office since the heat of this pandemic, just to be safe for everybody.
Absolutely.
Tanisha, can you tell us what you've been doing?
Yeah, I've done pretty much the same thing as well. I've been operating via Zoom conferences, as well as initially when the pandemic broke, reached out to all of my clients to kind of let them know kind of where we were going to be regarding court systems, and as well as, statuses of cases, how everything kind of is going to, was at a bit of a standstill until some of the executive orders start coming out and giving us some guidelines as to how we should maneuver through this process. And so just trying to keep them very much informed about how to deal with these parenting time issues. Going through this process is very difficult for, parents to accept the fact that, things might adjust or things might change. And so just trying to balance that out with the clients. I have not met with any clients in my office either. Just, to be safe. The issue is you really just don't know how people, whether they are asymptomatic or any of that. So just to be safe, I have been doing phone conferences and Zoom conferences, as well as like Google Hangouts, all of those different platforms.
Okay, that sounds awesome. I have been doing the same, meeting with my clients via my FaceTime app on my iPad and corresponding with them via email. A lot of my clients are faxing their information in, and we've just been corresponding via email. I'm not allowing anyone in my office at this time either. I'm not sure how that's going to pan out when the executive orders are lifted, but we'll work to see how that works out.
Yes.
I got a question here for you. Any of you either you can chime in, and I'll show that to you.
I see the question, how does parenting time work during this pandemic? It's my understanding, and I'm saying it like that because things are really, this is kind of a difficult time, particularly when it comes to parenting time, and especially if people are trying to modify parenting time. But it's my understanding if there's an emergency, there are emergency motions that are being accepted. There's a particular process, and Tanisha, you might be able to chime in on the specifics of that process. But in general, they're really not hearing those motions. And it's my understanding that all of the motions that were already on the docket up through April 30th have been adjourned, and certain types of motions are being heard via Zoom. And it's my understanding that the Michigan Supreme Court has ordered that the hearings will be via Zoom until further order. So I don't, presumably there's going to be some connection with whatever takes place after May 15th. So people are really to maintain their current parenting time order unless they're able to get some relief through an emergency situation. Is that your understanding, Tanisha?
That is absolutely my understanding. And of course, we are dealing with different counties. And so each county has their own kind of policy and procedure in which they're following. But for example, if this is an issue regarding parenting time in Wayne County, there are emergency hearings that are being held. They have to be approved by the court. They will be submitted and heard by one judge who is handling the docket, I believe, for the entire week, and they are rotating on that. They are accepting motions via fax as well as email as an option. However, you need to be very mindful about what's considered an emergency because everything has been moved, but the order that came out from the Michigan Supreme Court indicated that parenting time was to continue as normal, meaning if the non-custodial parent has parenting time set up for the weekend, yes, we are in the middle of a pandemic, but you do need to allow that parenting time to happen. However, as parents, we also need to take our own reasonable precautions, meaning if dad works in an environment where he might be an essential worker, the first thing is communicating with the other parent to let them know, hey, can we come up with some agreement, possibly set up some make-up parenting time that dad can have after the emergency, orders are lifted, something to that effect, setting up some type of Skype or way that dad can still communicate with the child or children during this process. So this is not some free reign to just allow one parent to unilaterally control the parenting time, because the expectation from the court system is that the parenting times are going to continue. So if you are going to take away a parent's parenting time, number one, you better have a very good reason for doing so. And you better be prepared to offer some make-up parenting time, because that's going to be the expectation of the courts.
Absolutely. Absolutely. And it's interesting that you brought up that scenario, because I actually am doing a mediation, and we're doing it by Zoom. And my client is a first responder. And the other parent is trying to utilize this pandemic as an excuse to change parenting time. And it's they don't want to. They really should rethink it, because when I go to mediation, and even if this situation ends up going to the judge at some point, I actually think it's going to negatively impact them, because you're not even considering the situation and what they're doing, and they're not in the medical field, but they're in the first responder field. So I hope for their case that they don't end up going to the judge, taking this to the judge, because it's not going to look very good on them at all.
I agree.
And, you know, to make an issue out of it, and the children aren't even in school, and you're not working, that other parent isn't working.
And you know, what's also important for parents to understand during this process is, even though you might be the custodial parent, that doesn't give your environment a pass, meaning that the child cannot become sick from your own household.
Absolutely.
So, you know, be careful about kind of making those decisions about taking away parenting time, because you don't know what's going on in the other parent's household. You know, there has to be some give and take there. And, you know, you have to be mindful of the fact that, you know, the kids are going through a process too. They're used to procedure, they're used to a schedule, and the idea is to keep that schedule going. Now, we don't want to violate any rule, but, you know, I also think that there needs to be some understanding about the fear that a parent is going through as well. I mean, we all understand that. I think we all on here are parents. And so, you know, when you have to kind of release a kid and not know, when you are watching, you know, things around you in terms of the death toll going up. Yes, that is a scary thing, but that's why it's so important to be able to communicate, because you can kind of get rid of some of all of that and that dispute, and that, because even the judges aren't going to really know how to deal with this, I don't believe, in terms of trying to hold one parent accountable for making what they might feel is a health and safety decision.
Absolutely, absolutely. Because I have a different client where one side is working every day, making deliveries at stores, coming in contact with all these people, and people aren't wearing masks or anything like that. And they have joint custody, but the other parent doesn't really, and the kids are old enough to be really concerned about going over there because of potentially getting the COVID-19 or being exposed. So it's a tough situation.
Very, very.
It is. Can you answer this question that you see above you?
Yes. Can you tell me how court dates are working in Wayne and Oakland County courts? I know that Wayne is doing Zoom court hearings. However, the movement in terms of when those hearings are actually taking place, I am not sure how they are, you know, what they're using as their reasoning, or how they're setting the schedule, so to speak. I have had some cases that have been moved that were scheduled for late March and early April. Those have not yet been rescheduled. So I think because of the large docket of Wayne County, it might be a bit of a time before we can probably see a lot of those movements, but I think they're probably focusing obviously more on the emergency motions and hearings first, possibly trials. And then, you know, pretrial conferences, status conferences will probably be last.
Yes, yes. I think all of those, besides the emergency hearings, have been adjourned. Yeah. And it's going to be quite a hectic situation when everything opens back up. It's going to be really hectic.
Yeah.
But at this point, as I mentioned earlier, from what I understand, at least for Wayne County, from what I understand, they're going to be proceeding with Zoom conferences. Not really sure about Oakland County. I don't have any, even though I predominantly practice in Oakland County, because of some transitions that will be making whenever this pandemic lifts. I haven't been taking any additional cases. So I'm not really sure what they're doing in Oakland County, but obviously they have to follow the executive order.
Well, Oakland County, I do know they are doing Zoom conferences as well. I have one that was scheduled for review early March, and it is now scheduled for May 5th, and it is by Zoom. So what they've been doing is emailing out to the attorneys a Zoom instruction sheet to handle in terms of how to go about setting up the hearing. And they are asking that any documents, exhibits, or any of those things that you would want the court to review during your hearing need to be provided to the court 1 week prior to the hearing that's scheduled. So that's kind of how I believe Oakland County is handling theirs as well. But emergency motions, again, are also all going first.
Okay, we have another question. Why was my stimulus check taken for child support? Either of you want to weigh in on that one?
Yeah, so this is a really tricky one for me because child support is functioning just like any type of tax offset. If child support is owed, there's arrears owed. Unfortunately, they are being utilized, they are taking the stimulus checks for that purpose. Do I believe that there is, issues and concerns about why that's one of the only things that is being taken regarding the stimulus checks? I think that's probably a whole nother platform or a whole nother session that we could do. But yes, if you owe back child support, your stimulus check will be intercepted.
And it's kind of similar to any tax refund that the non-custodial parent who owes child support, that tax return can be intercepted. So the stimulus check presumably falls into the same category. And even though it's a tough time, because obviously we're getting stimulus checks because of everything that we're experiencing in terms of a lot of people not being able to work. Some people may be receiving unemployment at this point, whether they have a business or whether they are, we're an employee. So it's a tough time, but I guess the positive way to think about it is if you have a child support arrears, at least that bill is going to go down. But understandably, it's difficult because everybody's trying to survive during this pandemic.
Yeah, I think my only concern with that is just how out of the many things that you can intercept a stimulus check for, child support, which very much affects our community a lot more than others. And so you have student loan payments that's not being intercepted by stimulus. So, it is tough because regardless of who's the payee, who the payer, who's behind, that doesn't mean that they may not have a need for that stimulus check as well. But you have parents who are going to have, 3 and 4 or 5 stimulus checks because of this interception. So it is quite unfortunate. But, again, just like you said, Gwen, it will reduce, what is owed.
Thank you. Can you tell us, let me just expound on the taking out the stimulus check. I'm a former Wayne County friend of the court worker, and if you are a married couple and you had your spousal portion of the stimulus check taken as well, you can file what's called an injured spouse form with the friend of the court to get your portion back. So I would encourage those of you who are married who had your stimulus check taken to file the injured spouse form to get your portion of the stimulus check back. Another question: how is child support determined? Anybody want to weigh in on that?
Chandrika, you probably be best at this. I mean, all I would add is that it is certainly a formula. One of the two important things to be attentive to, obviously, is the income of the parties and the overnights of the parents. But there are other factors that determine that, whether or not health insurance is paid by a parent, whether or not daycare is paid by a parent, whether you're filing as, head of household, whether there are other children who you are responsible for taking care of.
I said silence all phones before we go live.
I am so sorry. Okay.
We all do it, Tanisha.
Yeah, my dog started barking a minute ago, so I tried to put it on mute, so sorry.
How do I get back in here? What did I do?
But you're absolutely right, Tanisha, in terms of all the different factors that are involved. And, of course, there's the software that calculates it. And there's some aspects in regards to Social Security disability, veterans income, things like that can either be included or excluded. So there's a lot involved. So Chandrika, with you having all of this great FOC experience, maybe you can weigh in a little more on how child support is determined.
Oh, as far as child support determination, the thing you need to know is overnights is the deciding factor, but income is the main input. However, a lot of people think that they can shy the system by not properly reporting their income, especially independent contractors. But the court has a mechanism of what we call imputed income. That means if you don't tell how much you make, the courts will decide how much they think you could make with your earning potential, as far as if you have a degrees, you have a trade, and you're just exercising that. I have a few clients who were doctors who tried their best to avoid paying child support based on actual income. But if you're a neurosurgeon and you have the ability to be a neurosurgeon and you have the ability to make neurosurgeon money, then your child support will be determined on that neurosurgeon market analysis. So be conscious of that. So even if you're a fast food worker and you're and let's say you're working at a restaurant that's paying on the table, because that does happen. A restaurant that's paying on the table, they're going to impute the income of what a restaurant worker should make and put that into the formula. Also, there are deductions that you can take. So a lot of people work at unionized workshops. You can deduct the union dues that you pay. If you also carry insurance for the children, that is also a determination inside the child support factor that you're paying that. And also, you have other children other than the ones that child support is for. That's a determination as well. Not as big of a determination, but it is one of the factors that goes into the formula. So keep all of that in mind. Let me see. You got another question here. I used an online website to make a will, but because of the pandemic, it has not been possible to get witness signatures. Can electronic signatures be used to validate a will because of the pandemic?
I believe, didn't the Supreme Court pass something recently to validate the use of electronic signatures for witnesses in Michigan?
Yes, they did. Yes, they did. So I am a notary. I think I'm not sure, but I think we all may be. But I'm a notary, and the governor issued out an executive order regarding notarization of documents, and one of those was in the part of EPIC as well. EPIC is the estate's part of the law that governs probate issues such as wills and things like that. And we are able to do notarizations online and witness signatures online via a notary, because most wills in this state, if they're not a handwritten will, have to be notarized, should be notarized. I won't say have to be, but they should be notarized so that someone knows that this is the person doing it. I'm able to do notarization virtually. So if you want to contact me in my office, you can go to my website, LAWCIC. I put my banner up for you. So you can contact me directly and we can do a notarization over the phone. I'm currently using the WhatsApp because I have a lot of clients overseas and they prefer to use that app. I use the WhatsApp, and then I use the application also to record my clients notarizing, signing documents, and then they email me those documents and we do it that way. And then I send it back to them notarized with my new tagline based on this pandemic and the governor's executive orders. So it is possible, to answer your question, it's possible to get notarized witness signatures virtually.
Yes, and I believe in Michigan for wills, you have to for it to be valid, you have to have two witnesses. The notarization is optional, but like you, Kounsel, I always do the two witnesses and notarize. I just think that provides an extra level of protection and validity for these types of estate documents.
Correct. I got another question. Can you explain the difference between district court, circuit court, and probate court?
Well, just a quick summary. District court, if we look at things from a civil litigation standpoint, then it's a court that there's a minimum, what is it, 7,500 or something like that, or maybe that's a small claim court, but I think it's under 25,000 or something like that. Circuit court, I believe, if it's some sort of civil litigation, is 25,000 and up. Probate court is going to handle your estates if somebody has passed. It's going to handle guardianships. It's going to handle conservatorships. And although some distinctions between district court and circuit court is in a criminal arena, if there's been a felony, then at the district court, you're going to have the preliminary examination to determine if those charges are going to, I'll say, stick, so you get bound over to circuit court. And then circuit court would take that case over. If it's a misdemeanor, then those misdemeanors are handled in district court. Small claims is in district court. There could be some landlord-tenant issues in district court. Tickets are in district court. And you all can elaborate a little more. This is like a question that you need to review your textbooks. So I had to try to.
That's a lot of question.
Yeah.
But you're absolutely right, Gwen, with everything that you laid out regarding the district court. I know circuit court, when you're talking about civil, starts at $25,000 and up. So the monetary, in terms of what your relief you're asking for, really determines what court you're going to file in. There are certain things that would not fall into a district court category. For example, when you get into circuit court, you're going to be dealing with all of your family law issues. So you would never deal with friend of the court or, child support or custody in a district court. That would all be at the circuit court level. And so you're going to have certain divisions within circuit court. So you may have the family law division. You're going to have the civil division in circuit court. But when you get to the civil division, of course, you're dealing with anything above $25,000. And so when you start hearing about, $1 million personal injury claims, that's all happening in circuit court. And then the probate court is on the same lines as the circuit court, is somewhat separately depending on what county you're in. But for the most part, probate is sitting by itself, but it's on the same level as the circuit court, with the district court kind of falling below that. And then what else? I think that kind of answered it. And probate is going to deal with, obviously, Gwen, your, states, trusts, wills, all of those things that regarding decedents, inheritance, passing on, things of that nature.
Correct. Got another question here. Do you have to pay child support if you are not allowed to see the child? Tanisha?
That would be a yes, affirmative. They are mutually exclusive, which means that the same way that you must pay child support whether or not you're seeing the child, you can still see the child if you're not paying child support, meaning you're not going to be penalized by being denied parenting time if you cannot pay child support. So they work both ways. However, if you are paying child support and you're not allowed to see the child, the question becomes why? What's the reason why you're not allowed to see the child? Is it a situation where, there was a CPS investigation or some type of allegations of abuse or neglect? Is it just the other parent not allowing you to see the other child for their own personal reasons? Regardless of what it is, there is still relief there, meaning if the other parent is not allowing you to see the child, but you are, paying your child support on time, you're doing everything you're supposed to do, that's the point of filing a motion to enforce a parenting time schedule or to set a parenting time schedule, because the law allows for you at any point in time to request to the court a specific parenting time schedule and not kind of allowing the other parent to unilaterally control that. So you do have relief if you are paying child support, but for whatever reason, you're not allowed to see the child. If there is an order from the court that maybe has suspended your parenting time, that might be something that can be discussed. Chandrika, you can relay my information that maybe they could call my office or Gwen's office to kind of go in a little bit more detail about the reasoning behind why that did not, if there's an order from the court denying that parenting time, but the child support is expected to continue, because the idea is that both parents are required to financially support the child. So if the child is residing with one parent, the court's position is that, well, that parent is obviously, caring for and supporting financially that child. And so the non-custodial parent is required to do the same. Whatever the reasoning around the parenting time or issue can certainly be addressed to the court, though.
Absolutely. Yeah, a lot of people don't realize how important it is to address custody and parenting time before it becomes a permanent order. That's right. I say a permanent order, not, and it's not that you can't modify it, but the ability to modify, particularly custody, which impacts, parenting time impacts custody and all of that, to be able to modify custody and parenting time after that very first permanent order. The burden of proof is so much higher and it's so much more difficult, and people don't really understand that. So you really want to litigate as much as possible initially, so that you can get the kind of parenting time that you want, which is going to impact the child support.
Absolutely.
And more importantly, it's going to impact the relationship that you have with your children, which is the most important. But the thing that does bother me about the child support and the parenting time, when you're not allowed to see your child, it used to bother me that the recourse for not paying child support is so much more aggressive than the recourse for a parent interfering with parenting time. And that irritates me, because usually it's over something petty, because if it was over something legitimate, then the court would have done something about it, or CPS would have been involved. So somebody gets mad because the other parent is now dating someone else, or they remarry, or they get married for the first time, and they're mad because they didn't marry me, Yes. So now they want to try to withhold the child. So you've got to be ready to go toe-to-toe, and not to be, when I say toe-to-toe, I mean in the courtroom, because otherwise, the change is going to stay in effect. And the longer you allow the other parent to withhold parenting time, they can turn around and file a motion to modify and say, hey, they haven't been seeing the child, and this is the new pattern. The child hasn't seen the parent in 6 months, or has barely seen the parent in 6 months, and they can end up with that parenting time changing altogether, which could even increase the child support. So that's something that bothers me.
That is so true. And I just wanted to add that it is so important for parties to participate in this process from the beginning. If you get a notice from a friend of the court from any county regarding, the custodial parent wanting to establish custody or child support, which normally it always starts with the form of child support. However, don't not show up. Yeah. Show up, be present, be heard, because that's the beginning of the paper trail. That's the beginning of you at least getting the opportunity to relay to the court your position, that you are a present parent, that you want to participate in this child's life. All of that's on record. And so your absence kind of shows the court either that you don't care or you're not involved. And so they're going to go ahead. It's not going to stop the process. They're going to set an order, a uniform child support order for you to pay child support, whether or not you are present at that hearing or not. And I know there are a lot of, fathers who get very frustrated with the system, but you must participate because that's the only way you can change the process. And as Gwen was talking about the idea of, if you don't participate, you're stuck with an order. And then now you have a very, very difficult uphill battle trying to address modifying that order. Because according to the law says that whatever the order is in place, now you have to demonstrate to the court that there has been a change, some type of change of circumstance that puts the child at the center, not the fact that, your hours at work may have changed. It really has to center around the child. And when you cannot make an adjustment to address that modification, now you are stuck with whatever the other parents set as the schedule. And so to even add sometimes one day, you might have, Thursday through Sunday and want to add a day. That day is going to cost you a lot because you never kind of opened the door for yourself to establish, how you wanted that schedule to be. So it's extremely important to be participatory in this process, whether it's child support, because they're going to come up with a number, whether or not they know where you work, whatever, they're going to come up with a number. And it makes it very difficult to come from behind. And depending on what county you're in, some counties are a lot more aggressive when it comes to child support than others. And so, you'll be $500 behind and you're getting a bench warrant, where in another county, you might be $30,000 behind and no one's paying you any attention as of yet. So, be conscious and attentive to that and just don't ignore it because it doesn't just disappear.
Okay, we have a question that's a little off topic from today. This is the actual family law and probate law session, but I am a labor and employment law, so I will answer the question because the person is watching. And the question is it difficult to prove hiring discrimination? I will let you know that on Wednesday we'll be tackling labor and employment law extensively. And to answer your question succinctly, is it difficult to prove hiring discrimination? Yes. It is very difficult to prove hiring discrimination because first off, you're not working there yet, so you don't actually have a paper trail of anything. So it's very difficult to prove. But if you have people who have different people who have applied who are protected in a protected class, and those classes are based on your sex, male, female, based on your race, ethnicity. So if you're Hispanic, Black, a woman, based on your religion. So if you're practicing Catholicism, Muslim, if you're part of one of the protected classes, and others who are part of those protected classes who have repeatedly applied for certain positions that have been denied, you might want to get together and do something and contact the lawyer. And if you want to contact me regarding that, I'm gonna put my information up here. You can contact me via my website, lawchic.com. Thank you. All right, we got another question here. How do I get power of attorney with my mother who has dementia?
You cannot.
When
you can't get power of attorney over someone who is not mentally competent, because that's the initial standard. And that's why I really, when I do estate seminars, estates and trust seminars, I tell people that there are certain types of documentation that everybody needs after you become an adult. Powers of attorney and patient advocates are really important. Everyone over 18 should have a patient advocate, and that patient advocate is, in regards to medical decisions. Power of attorney are of course, in regards to handling one's financial decisions and things like that, because the power is being handed over from, in this case, you asked about your mother. So it would be your mother handing over the power to you to handle her financial affairs. If she has dementia, she does not have the mental capacity to hand that power over to you, which is what a power of attorney does. So you would have to file a conservatorship case in the probate court. And, you know, if you wanted additional information, you can contact my office. It'll probably come up on the screen shortly, but that would be your recourse.
Thank you, Gwen. Another concern of mine is people who call my office with that question all the time after the fact. The time to do your proper planning, like Gwen said, was prior to anyone's mental capacity being challenged. So we encourage you to reach out to your attorneys, and we are 3 of those that can actually do your estate planning for you. It's something very simple. My father told me earlier this year, death is death, and people should not be surprised when it does happen. Yet we don't properly plan for such, and we should. We know we're going to do 2 things in life, live and die. So planning your life out is not a thing that you should think that is something that you can put off. You cannot. You cannot wait to put it off. And I would encourage you to contact either of us to properly plan your life. I like to say, would you like to control your relatives from the grave? I know I do. I want to control them from the grave, and I will, because my stuff is in order. Okay?
Absolutely.
Okay. It's another common question that I get in my office all the time is, do I have to show up to a hearing once I receive notice? Anyone want to weigh in on that one?
What was the question?
Do I have to show up to a hearing when I get a hearing notice?
You should show up, because depending on the type of hearing, and Kounsel TANISHA Davis kind of mentioned this earlier. A lot of people think they get, okay, for instance, they get served with a summons and complaint. First of all, they think if they avoid service, it's going to go away. Or if they get served and they don't respond, the case is going to go away. It is not going to go away. They are going to find a way to either have you served by alternate service, which could be an alternate way that you would never come in contact with unless you read the legal news or something like that. And most of us don't read the legal news. It is not going to go away. So it is important for you to be at all hearings, because otherwise anything can happen. You know, depending on the type of hearing, if you're going through a divorce and you don't show up, you could end up with a divorce judgment that darn near gives everything to your ex-spouse. And now you get that judgment and you're upset. Well, you'd have to kind of be upset with yourself if you chose not to show up. So anything can happen at a hearing if you choose not to show up. So as long as the other side can prove through a proof of service, a legitimate proof of service, that you were served, then you would be subject to whatever took place. Now, sometimes you can file a motion to set aside, but it's a big risk, because now you have to go through the legal hoops when it comes to filing a motion to set aside. You probably need to hire an attorney to do that, and you may not win, because you really would need a serious good cause reason as to why you didn't show up.
And you know what, Gwen, you're absolutely right. And as an attorney, when I default someone for not responding to a summons and complaint, or, not appearing, the first thing I'm going to ask for is costs. If you want me to set aside a default, you're going to pay for it. And so it's easier, much easier to just appear. You don't have to agree with what's in the documents. Understand that the attorney who may have been filing that, they don't represent you. But the only way for you to be heard and your portion to be heard is to be present.
Absolutely. Absolutely. The only time that it's not necessary is if you have already signed a consent order. You've agreed with whatever the other side is proposing. You have seen their proposed judgment or order, and you've signed it. And at that point, you have already participated, and unless you're the plaintiff, you don't necessarily have to go, but otherwise they need to be there.
And always check with the judge's clerk, who's a very, very resourceful person in the courtroom. But always check to make sure what the judge's policies are. Some judges, no matter what, require both parties to be present. And like with divorce proceedings, Gwen, you're absolutely right. Once you have a judgment, a proposed judgment, and it's been signed by all the parties, the only person who needs to appear might be the plaintiff. But depending on the judge, and every judge has their own policies and procedures in their courtroom, they may say, I want all parties to be present. So make sure you're aware of that. You rather appear and then have the clerk tell you that you can go versus not appearing. And then, you know, at a certain time in every courtroom, those parties who have not been, have not appeared for whatever hearing, they're going to be, held accountable. If it's a criminal case, it's going to, potentially be a bench warrant. If it's a divorce action, a family law action, whatever relief that's a party was asking for potentially will be granted. So just be mindful of that.
Right. And as Tanisha stated, you can catch a bench warrant, not just in criminal court, but also in family court. And a family court bench warrant weighs just as much as a criminal bench warrant. And you should be very much aware of that. So you should attend all hearings. And if you if you have any doubt in your mind, you should attend the hearing so that you actually know what's going on. Because after the fact, it's very hard, because most likely a bench warrant will be issued, or you will have an order in place that you had no say-so in.
Yeah, especially a show cause. Like if you've gotten a show cause in family court for failing to pay, child support or something like that, those certainly will result in a bench warrant. And they're difficult to get from up under, because if it relates to child support, the statute says that, if you are arrested on a child support bench warrant, technically you might be required to pay 25% of whatever it is that you owe. So if you owe $50,000 in arrears for child support, then that could 25% of that could potentially be your bond. And so if you're a person who's working, you have a family, think about what that loss could be, because you could not get out. You could lose your job. It could be a lot of, domino effects that comes from just not showing up.
Okay, we got another question. Why do I have to wait so long to get divorced if I have children? Gwen?
There's a 6-month statutory waiting period when you have minor children. I don't know the history, but being a parent and having been divorced, I've remarried, but having been divorced, it's my thought process that many times, and all of us are family law attorneys, many times people come and they think about filing for divorce off of an emotional response, as opposed to some, of course, there are people who have gone through certain things and they've made a concerted, informed decision. So it gives time for people to really determine, is this the way that they want to go? Also, there's other factors involved when you go through a divorce with children as opposed to a divorce where there are not children. You're going to have to decide custody. You're going to have to decide parenting time. You're going to have to maybe decide domicile. You're going to have to decide child support. Those are big issues that are not involved with divorce cases when there are not minor children. And those issues can be complicated. If one or both of the parents are now in relationships with other people, or they have other children. There's so many factors. And so it just takes more time, and it should take more time, because obviously, you want to negatively impact all of the parties as much as possible and try to positively impact them as much as possible. So there's just so many more people involved. So I believe for divorces with children, they want to have those done within at least a maximum of a year. There are times, depending on the case, depending on factors that come up, depending on how much discovery is needed, it can be longer than that. But they want those cases done sometime between 6 months and a year.
Correct. Yeah, did you want to weigh in, Tanisha?
No, she covered it. She covered it, absolutely.
Okay, I got another question here. Why do I have to wait so long? Why do I have to wait so long? Do I have to give up half my pension if I get a divorce? Tanisha?
Potentially, yes. All marital assets, well, anything accumulated during the marriage is considered a marital asset. And so by right, either party has kind of a stake in whatever asset was accumulated, whether it's a 401k, a pension, but by consent, you may not have to do so. So it really is a matter of, are you entitled to a portion of your spouse's pension if you get a divorce? Yes. But can you agree not to take it? Can you both consent that, hey, you keep your pension, I keep my pension? Absolutely. But yes, it is considered part of the marital assets and subject to division. But there are some exceptions. It just depends on also how the pension of the spouse is put together. But regardless of whether it's, $200 in the kitty or $200,000 in the kitty, if it was accumulated during that marriage, it is subject to division. And doesn't have to be half, because in family court, it's not about, it's not what you call equal, it's what they call equitable. So equitable could mean 40% of the pension. You know what I'm saying? If it goes to a trial, but everything, in terms of you're possibly going to mediate, you're going to come to some understanding or agreement about what that division is, but it doesn't have to be 50%.
Yes, and that's correct. And basically, it's been my experience that aside from going to trial, there's this kind of underlying policy that it is a 50-50 split of what has accumulated during the marriage. And so you do want to do your due diligence, which is part of the discovery process, because sometimes, a lot of people are in their second marriage, or maybe they got married and they've been working somewhere for 10 years before they got married. And so if your pension, if you have 25 years of pension, but you only have 12 years of marriage, then only 12 years of your pension is subject to a split. And if a person was to go to trial to, inclusive of fighting a 50-50 split, because technically, I don't believe the statute gives the percentage of the split. It's just, it has become the practice in the courts to split it. And people don't tend to argue it unless they go to trial. And if you do try to argue it, typically the judges are going to mention, I would probably, if we went to trial, they'll tell you, if we went to trial, I would probably split it. But depending on the marital estate, depending on what other assets are involved, and what other assets could be moved around, like what you were saying, could determine whether or not there's a strong argument for it to be less than a 50-50 split. And of course, as you mentioned, depending on how much how much are the retirement packages for each spouse, because sometimes it's a wash, and you've got to pay somebody to do a quadro in order to split that. So, you want to look at, does it make financial sense for us to split it? If you've got 100,000 and I have 102,000, in the pension, does it make sense, to fight that? But in general, it's, as you mentioned, it's 50% of what is accumulated during the marriage, and the practice is a 50-50 split.
And the other thing I wanted to add is, for example, I am dealing with a case right now where the parties have been married for over 19 years. Wife has a 401k valued at almost $350,000. Husband has a very small 401k, but he is on his second job. He retired and went back to work. And so he's collecting on his pension from his first employer. And so the idea was he's already collecting on his pension. And so she's certainly not going to get a whole lot, but she's risking giving him half of her $380,000 401k. And so the parties, at first she was really fighting for the pension, but I'm telling her, you actually have more to deal with, because if you got to do a quadro, you're going to give him half of $380,000 for approximately $1,000 a month, if that, because he was only getting $2,500 of his pension already. So you got to have to weigh what those assets are. These parties have been living apart now for the past 5 years. And so sometimes you kind of have to leave well enough alone, because that's all she's going to have to deal, in terms of her retirement. She's not eligible for a pension. All she has is her 401k. So to give him half of that, so you have to balance. But the parties were able to agree together that he would keep his pension, she would keep her 401k. And so, sometimes it's a matter of, is it worth the fight? Because like you said, when you have a party where one person has 401k, or even both of them have 401ks, now you got two quadros you have to prepare. So, there's still money involved to get money, but you got to figure out what's most important to you. And if there are things that you and a spouse can agree on, try and agree on those, because then that's less that you have to fight about.
I just would comment that many times, if not all the time, especially in a situation like what you mentioned, is to do the numbers.
Yes.
Because depending on the age of a parent, of a spouse, if they're getting $2,500 a month, you calculate that. What is that, per year? What is the projected amount that I would get? Which is, obviously no one knows when they're going to pass. If I was representing that other person, I wouldn't have let that $380,000 slide.
See, and I was representing the $380,000. So that's why I'm telling her, like, just chill out.
So he must not have been represented by counsel. Because
and then
you want to look at that.
When people have moved on with their lives, it's easier to let go of things. When there's a lot of resentment there, sometimes it's hard to just walk away. So
yeah. He'll be thinking about that half of that 380 in about 6 months. Right? But it'll be too late at that point.
Yes. What is a quadro?
The next follow-up question is, what is a quadro?
It's a qualified domestic relations order, and that is the document that allows the plan administrator, whether it's from your pension, your 401k, whatever your retirement vehicle is, it legally allows them to split the retirement in whatever way is in that document. That document dictates how it's to be split, who is the alternate payee, how long, whatever the terms are that come from the consent judgment of divorce.
That's correct.
Yeah, I just letting people know that you're getting a divorce and you're quoted a divorce amount from a lawyer, there's a built-in, if a quadro is required, there's a built-in cost for quadros as well, because that's an expensive cost to have a quadro drafted, because usually attorneys farm that out, but I'm one of the few attorneys that draft my own quadros, because as a court worker, I got to see pretty much every single one of them. Yeah. So I already know how they go and what they expect, and I have contacts with pretty much all the major employers that have quadros. So if you're interested in a quadro attorney who does those, that would be me, LAWCHIC.com, thelawchick.com, and reach out to me there. We got another question. Let's see. Let's get that one. What is a putative father? Tanisha?
Here we go back to law school. So if I'm not mistaken, please correct me if I'm wrong here, but the putative father is the father who you is determined to already be the dad. Am I correct here?
Correct. Here in Michigan, we have what we call the putative father. That's the person that the court has deemed to be the father. There are plenty of issues when it comes to, because a lot of us are single and we're out here mingling, and sometimes we mingle up upon children. And sometimes we don't know who the father is of those children. And so if the father signs the birth certificate or signs the acknowledgement of parentage, he is deemed to be the putative father. And that's a high threshold to overcome once you've acknowledged through all those documents that you are the father. As a follow-up question, unless you want to expound on that, Gwen, the putative father?
Yeah, I think the putative father is the father, and I wanted clarity too. So when I just Googled it, it talks about the father whose legal relationship to a child has not been established, but who is alleged to be or claims that he is, say, the biological father, as distinguished between the legal father, who could be that person who signed the affidavit of parentage, and that father becomes the legal father, and he may be not the biological father, and the situation where you could have the biological father who did not sign the affidavit of parentage trying to come forth and say, you know, I am the father, and could be deemed like the putative father. I believe they changed some laws, because once somebody signed an affidavit of parentage and it went through the courts and became deemed via a court order or a judgment that they were the father, if they weren't the biological father and the biological father came forward, he used to not have any standing. But didn't they make some changes where there's a possibility in a situation like that where you would have standing? And maybe that's why this person is asking the question about what is the putative father.
So there's go ahead.
There's a process now. They have altered the law to be able to come now. They still put parameters on it. I'm not clear right now on the actual time frame, but there is a little quirkiness in the law right now that says that if you didn't know, you have a time frame to come, and then there's reasons that you can give for the reason why you didn't come at an earlier time to say that I'm not the father or that I am the father, to be able to establish paternity. And I would encourage you to contact one of us if that is an issue for you of determining parentage of one of your children, to contact. You can contact me at my office at lawchick.com. You can contact Tanisha at hers. This is what we do as far as establishing who the parent is of a child. If you are not aware or don't know who the child's parent is, you can also contact Gwen at her office to establish a paternity for your child, because there are nuances in the law that you can actually use now to try to establish parentage of your child. So even if but this is for the courts, it's a minor child, not a child as an adult. If you got issues now and the child is grown, you might want to go get your own little kit and do it that way. Get a paternity test, do it that way. And also, for those who don't know, Oakland County and Wayne County now will do the genetic testing for you. I believe it's $45 in Oakland County. I'm not sure what the Wayne County cost is, but they will test for you if you start a case there to establish a paternity. If you want to know who the father of the child is. Also, if you are aware that a child support case exists on a child you think is yours, we can include. You can file a motion to be included in that case to establish your rights as the father. So contact either one of us. regarding that, if you want to establish your paternal rights, because we're all available and highly equipped to be able to handle that matter, because there are quibs in the law that allow you to come in now and establish a proper paternity for your children. Okay.
Can I make
that leads us to,
Can I make one comment? I typically advise potential fathers to not sign affidavit of parentage, typically, because you don't know. I mean, I know many times men want to make the assumption that my woman would not deal with anybody else, or if my woman told me, you know, that she hadn't been with anybody else, then that I'm going to believe her. And I understand trust and things of that nature, but I have had too many cases over the 25 years of practicing law where men have found out that they weren't the father, and sometimes the mother knew that he was not the father, but he had the deeper pockets, financial pockets. I even had one case, and this was a young man, he loved this daughter, and she filed something in court coming forward saying he was not the father, and he had been paying child support for 2 years. You know, we had gotten a parenting time schedule and all of this, and she came forward because she knew who the actual, the biological father was, and she didn't go after him until, she didn't try to change anything until he passed, because his Social Security was going to be higher than the father who was now the legal father, than the child support. He was a young man. He was about, I don't know, 25 to 28. He worked hard, but that Social Security was going to be, this man was devastated. And I've seen too many other cases where the father ended up not being the biological father, and we had to do certain things to change and terminate child support orders and things like that, which can be hard. You can't always do it, but yeah, I tell men, if you're not married, obviously, if you're married, you're not going to have an affidavit of parentage, and there's an assumption that the husband is the father. But if you're not married, I know you're going to make the mom, the pregnant girlfriend, mad, but well, I guess she would have delivered the baby, so she wouldn't be pregnant. But you know, you got to think forward. And I just tell people, don't tell potential fathers, don't sign those until you have a genetic test.
And I just want to add to that, the statute references that up until a child is 3.5 years old, that's your threshold. That's your cutoff point in terms of determining paternity. So if you have been deemed to be the dad, the putative father, and you have not had genetic testing, and you decide to have genetic testing, say, when the child is 6, because people in the neighborhood starts to talk, or you've heard a rumor, now you're too late. So you need to get it early. You need to get that testing early. And as Chandrika mentioned, there are some nuances in the law that will allow some exceptions, but just think about 3.5 years old. If I don't know for an absolute certainty that I am the father by the time this child reaches the age of 3.5, I am stuck. The other difficulty that must be addressed is a lot of dads will ask me, she knew I wasn't the father. I've been paying child support for 8 years. Can I get my money back? No. And the worst part about this is that even if you know, and even if she knew, there's no recourse for you to litigate against her civilly. You can't sue her. You can't, sue her for misrepresentation or fraud or any of that, which I think is unfair, because it's unfair for a woman to benefit financially from someone with the knowledge that they, you know what I'm saying? If I can get charged for welfare fraud, why can't I get charged for child support fraud? So you have to be very careful, like you said, Gwen, about signing that document, because that document, in very, very small writing at the top of that document, it tells you that the mother is still presumed to be the custodial parent. So yes, you've signed it. It doesn't put the dad in any better situation for signing it, because she could still, no name has to be on that affidavit. No name has to be on the birth certificate, but that doesn't stop her from going down in front of the court and filing an action and saying that you are the dad and she wants to collect child support. So just be very careful about making those connections and getting some clarity, and knowing that you do have a very short window to contest it.
Correct. Thank you, Tanisha.
Welcome.
Okay, we have another question of, okay, so kind of probate related. If my mother left me a house when she died while I was married, is my spouse entitled to ownership of that property?
No.
Gwen?
It really depends on what you did with the property after you got ownership. If you moved your husband into the house and that house became the marital house, it's now the marital house, and you would have to you can try to argue separate property, because, you know, separate property is any property that was not accumulated during the marriage, and typically separate property is property that's been inherited or something like that. But if you make it, bring it into potentially the marital property pot, then they can argue that this property is marital property, and if there was a divorce, then they could try to make a claim. It depends on the facts and the situation as to whether or not they would be successful at that. So, you know, if you they don't automatically become entitled to any ownership or have any ownership interest in it at all. But you have to be careful about keeping it separate. So if you rented that house out, then I would suggest that any rental properties, you don't put it in a joint bank account. You have a separate account, so that if there's a discovery request to track that money, then everything is separate, and that way you can keep everything from that separate property that you inherited separate, and avoid or potentially win against any claims that a spouse would have in say a divorce.
I was going to say the same thing. My first word that came to my mind was commingling. If
Absolutely.
you commingle anything that was deemed separate initially, you lose or you waive the separate claim afterwards. And so she's exactly right in terms of outlining that if mom left you a piece of property, and even if, for example, you rented it out, but you're using money out of your joint bank account to say fix the property up, now you're contributing jointly to this, you know, piece of property that you said was separate. And so those kind of interactions between funds and sharing of funds, whether it's funds coming from the spouse, or, you know, say he's the one paying the taxes on the property, but yet you handle the mortgage or you handle all the rent. It's all, you know, that type of commingling will cause all kind of problems and will remove that tag of separate property and turn it into a marital asset. But initially, if your mother passed and you found something that said this property belongs to you, at that juncture, it's separate property until you start making a move on it and doing anything that kind of intertwines the spouse or the marital fund.
I just want to take a quick break because we're a little over halfway through the broadcast, for you guys to state again what it is that you do and how to reach you. Gwen?
Yes, I'm Gwen Davis-Yancey. I'm an attorney and mind shift strategist. I've been practicing family law and estates and trusts for over 25 years. And I'm actually transitioning into being a friend of the court referee once this pandemic lifts. So, but I will be continuing. I do life coaching. I really, after doing so much with family law clients, it's really important that you're able to shift the way that you think, shift your habits. That helps you when you're going through a case, and it helps you after, because everything really starts, that new beginning starts when that case is over. So I will be continuing doing life coaching that focuses in on being able to shift the way that you think and mind shift strategies.
Thank you so much, Gwen. Tanisha?
Yes, hi. My name is TANISHA DAVIS. I am a family law attorney. I'm also a CEO and founder of a mobile app called Kounsel Konnect. I've been practicing family law for the past 12 years, focusing primarily on high conflict cases, change of domicile, custody, and very, very detailed parenting time issues. And my practice is located in Southfield. I practice in all of the Tri-County areas, so primarily Wayne County, Oakland County, and Macomb. And I can be reached at my office at 248-996-8701, but I am presently working remotely, and my email as well.
Great. I am, again, Chandrika Simmons. I run the boutique law office, The Law Chick, and here in Oakland County. I service the Southeast County area. So I go to Genesee County, Washtenaw County, Macomb County, Oakland County, and Wayne County. And I do family law and civil litigation. And I also do real estate law, which is part of my contractual law practice. I do represent a couple of people in the entertainment industry as well, that being dancers, DJs, fashion designers, and basketball players who didn't make it to the pros. And so if that's something that you're interested in, to get representation for someone to actually read your contracts over and negotiate your contracts for you, I'm available for that as well. And I'm located at my website, lawchic.com, thelawchick.com. I'm also at my office, 248-732-7559. You can reach me there. And I'm glad to be here. And I'm also glad that the Black Women Lawyers Association, for which I am the immediate past president, current treasurer, allowed us to use this platform to be able to educate the general public regarding family law issues and highlight a couple of our members, Gwen and Tanisha. They are awesome litigators, and we want you to understand that we are available here for your services, and you should come and seek us first before you go anywhere else. I got a couple of other questions for you ladies. Let me get that.
Gwen, I wanted to ask you, where are you going to be a referee at?
Wayne County.
Awesome.
Yeah.
Congratulations, Gwen.
Yes.
Thank you. So I might see you all from the other side.
Woo.
Yeah.
It's going to be even better.
You.
Yes.
You'll see us. We have a question now. I have a bench warrant for child support. What should I do? Tanisha?
First, the question would be what county? But regardless, maybe if they can answer that question, and it might just adjust just a little bit. But it really does depend on which county in terms of the procedure that you would take. If this was Wayne County, the first question would be bench warrant. Are we in felony non-support status, or do we just have, a portion of our child support payments that have been missed? Because if it is felony non-support status, you're in a completely different building with a completely different process and procedure. So what I would ask is possibly if they could contact me with a little bit more detail, I can give them some details. However, just on a general basis with Wayne County, when there's a bench warrant, the first thing that I try to do is contact the judge's courtroom to determine what day they may handle bench warrants. Bench warrants are normally handled in Wayne County on the, I believe, the 19th floor, 17th or 19th floor, where you will meet with, you can go with an attorney or you don't have to. It's a very, very kind of compact, crowded day that day. There are a lot of people there. But you would meet with a representative from Wayne County front of the court to try and discuss how to resolve the amount of monies that might be owed. The bottom line is most front of the courts, they're looking for a payment. And so some form of payment could potentially get you out of bench warrant status, but it also depends on how much is owed. So if you are a few payments behind versus having paid anything in, 4 or 5 years, it does change, the amount of what potentially they may be looking for. So they're going to want to, ask some questions about what your employment is and all of those things to determine if, possibly you need to be doing a modification for your support because something has changed. But the bottom line is each order is its own individual order. And so if you owe $200 this month and $200 next month, each order can create its own bench warrant. So not to say that you'll have 10 bench warrants out there, but it just will begin to kind of add up. So you want to, number one, at least try and set some type of schedule, which is what front of the court will try and do, is set some type of payment schedule on those arrears that you really do need to try and keep up. Otherwise, you're going to keep getting, show causes and bench warrants to come and take care of. But as I had mentioned earlier, the idea in the statute reads that when there is a bench warrant, you are required technically to pay 25% of what you owe. It is helpful to have an attorney present because that can be negotiated. Sometimes, when you don't have an advocate or a voice to speak for you, that's exactly what they're looking for, 25% of what you owe. And the average person potentially does not have that. So it's very important to be able to have some type of representation to advocate for something that's reasonable. But you can get around a bench warrant, but you can't get around it by not going and showing up. So don't be afraid to go by saying, oh, if I go down there, they're going to lock me up. That's not how, typically it works. Like I said, the idea for friend of the court is they want that money so that the child who it's supposed to be covering can be taken care of. And that's mainly what they're looking for. They recognize that by locking you up, that may mean that, the child cannot be taken care of financially. And so they are willing to kind of work with you, but you kind of have to go and at least deal with it, address it, and be honest about what your income is and what you can pay.
Absolutely.
Gwen,
yes. And, it can be a factor as to how the bench warrant, why the bench warrant ended up being issued. Yes. Because, for instance, if there was a show cause, which is a hearing for you to show why you have not been paying child support, and you missed that show cause, or maybe you've missed 2 or 3 show causes, and now there's a bench warrant, it's going to have a different impact than a straight show cause or something like that. But if you have a bench warrant, you definitely want to go in, get the information, and deal with it immediately, because otherwise, just like any kind of warrant, you could be driving your car, you could fail to put your blinker on and when you're making a right-hand turn, and if you are pulled over by the police and they run your name and they see there is a bench warrant, it doesn't matter if it's child support or some other type of warrant, they will take you in and process you. And now you are having to deal with that child support bench warrant from a totally different perspective. You're in, you've been cuffed, you've been, fingerprinted and all of that. Now you're brought into the judge's courtroom with all the other people who have some sort of criminal warrant that is being addressed in that particular courtroom, or other people that have been brought in on a child support warrant. and you're dealt with differently as opposed to what Kounsel TANISHA was talking about, where you voluntarily come in, you're able to talk to people from the front of the court who and you have not gone through being handcuffed, fingerprinted, and all of that, and you have a better likelihood of being able to work out something. Because otherwise, if you get arrested, that bond is going to be that 25% of what you owe. And once you get to court, you may be able to you're going to get an attorney, because anytime there is, an arrest, just like any other kind of criminal case, you have a right to an attorney. But so you want to deal with it as quickly as possible so that you don't find yourself being arrested and going through that whole different process than you would if you walked in and got the information, found out when you can come in and handle that child support bench warrant. It's really, really important. And plus, it has a different impact when your attorney, or even if you're, representing yourself, you can say, hey, I came in on my own volition. I came in voluntarily, as opposed to someone you didn't come in and the bench warrant has been issued 6 months ago or 5 years ago, and you've been ducking and dodging it. Now you're going to have a hard time. So it's really important to take care of those bench warrants ASAP.
That is so.
Okay, we got another question. Okay. I'm getting unemployment. Will they take child support for my unemployment? Tanisha?
Yes.
Okay.
I mean,
that's true.
That's the simplest answer that I could. Yes. Any form of income that you are receiving, they likely are going to take child support from it. They're not going to take your entire unemployment check, but they do take a percentage of that, and it may not be your entire amount in terms of what's owed. That could potentially create some kind of arrears. But yes, they will take child support from your unemployment simply because your unemployment is coming because of an employer that you had. And so that employer is no longer paying you. However, the state is paying you through unemployment insurance and, with your employer. And therefore, it's almost just like unemployment is taking the place of what what will be coming out of your actual paycheck.
Got you. Do you want to weigh in, Gwen?
No, she said it very well.
Yes, she did. Okay, I've got another question here. If I am abused during my marriage, is that a factor in determining marital assets or custody? Gwen?
It can be, and marital assets and custody are two completely different discovery processes and all of that. It can have an impact in terms of how the marital assets are split. You really want to hire an attorney. You really want that attorney who's very strategic. And it can also be dependent on how or whether or not you can prove abuse. What type of abuse is it? Are we talking about emotional abuse, verbal abuse, physical abuse? Because there's a big distinction. I would venture to say that anybody, and I'm not saying this to make light of abuse at all, but most people in some sort of relationship could claim verbal abuse or emotional abuse, because just in relationships, there's such an emotional component, and people can get angry, or even if they're not angry, one person can kind of have a sarcastic personality or whatever, and another person can consider them controlling or consider them verbally abusive, because there's a fine line. It doesn't necessarily mean that someone is cussing someone out or calling them stupid. It's very personal. I've had clients where none of that took place, but they felt controlled or they felt inferior, or whatever the case may be, and it wasn't because there were direct words that were being said. So you want to be able to You know, I used to tell clients with certain types of situations, let's plan this out. Because sometimes people file too quickly. Let's plan out. Let's develop a track record of what it is or some of the things that we need to prove. So it can have an impact on determining marital assets, depending on what those marital assets are, and depending on the type of abuse. Custody, if you're being abused, it may or may not have an impact unless it's physical abuse or the verbal abuse is in front of the child. And when it comes to a lot of family law cases, a lot of things boil down to who your judge is, you know, because family law is such a gray area. You can make an argument, the same argument in front of one judge and in front of a different judge, in front of two different judges, you can make the same argument and get two different, completely different rulings. Because just like anybody else, people bring in their own personal view, whether they're supposed to be neutral, but I mean, how many of us can really be neutral? So hopefully that answers that question.
It does, and I want to expound on Gwen what you just stated, because I have a couple of cases, and both of them are in Wayne County. When this issue arises, you have judges who will not split children up. So let's say you have children that have different fathers, or you have children that have the same father, and one child wants to go live with the father or with another parent, and they have filed for a change of custody. There are judges in Wayne County who will not split children up, and then there are judges in Wayne County that will split children up, and that's so you can't go by what happened over with your friend's case or somebody you know's case. The facts are different for each case, and the judges are different for each case. You never know what you get, and you have to be cognizant of the fact that we all carry biases. Yeah, and that doesn't stop when it comes to the bench.
Yes. I agree. I just wanted to add to that, just in addressing the issue of abuse with custody. When you start getting into custody, you're going to deal with what we call the best interest factors, and there are 12 of them. And one of them deals with whether or not there has been abuse, whether it's in front of the children or not. And so it is one factor out of many that is considered as it relates to custody. But you are also, as it relates to Michigan, you're in a no-fault state. And so seemingly abuse is not looked at it's not looked at lightly by judges, but it also, you're not going to, rake in all of the assets because there's been abuse in the marriage. And so you don't get to kind of, the abuser doesn't necessarily get penalized by the court with assets or with, by taking assets away because of the abuse. Where it will become important is if this is an issue that goes to trial. Abuse might be considered as it relates to, like Gwen was talking about, the different types of abuse. If there has been, emotional and mental abuse to the extent where, one person is so controlling financially that the other person couldn't work, might end up being a situation of spousal support. So it can, these kind of issues are case by case. And Chandrika is very, very correct in that it really depends on what judge you're in front of, because each judge that gets on the bench comes to the bench with their own issues from their own backgrounds and environments and what they think is correct and proper. And that is then interjected into the decision-making regarding how your case is dealt with. So although domestic violence and issues of that are becoming a big thing in the court, and it's very intolerable, I don't want people to begin to think that it somehow puts them at a heavy advantage, because it really does depend on who's making the call, who's making that decision.
And unfortunately, it is extremely easy to get a man arrested for an alleged domestic violence.
It is.
And unfortunately, there are many, many situations in which the man is wrongfully arrested because the allegations are completely false. And you don't have to be, injuries don't have to be apparent for it to be domestic violence and to prove domestic violence, but it is abused. And the courts are aware that domestic violence allegations are abused. And unfortunately, again, many times and there are men who are domestically abused, but not as many. Because I've had a client and a father, well, he wasn't, they didn't have any kids, but a man that was abused. But that's not as often. But many times the women who are physically abused, seriously physically abused, are not the ones who are making those allegations.
Exactly.
And it's really unfortunate. I can recall two clients, well, they came in for consults, and one of them, she was in the medical field, made very, over 6 figures, and was contemplating divorce, yet it had not been 30 days since she got out of the hospital from being knocked through a as they call it, like a patio or glass. She was seriously beat up. She showed me the pictures, and she's contemplating, well, I'm here trying to weigh my options. And, I told her there's only probably been 5 people that in my 25 years that I've said, you need to get a divorce, because that's not my decision. But she was one of them, because she was beat up really, really, really bad. But I agree in terms of, there's a lot involved as to whether or not there's a connection between marital assets and abuse, and the custody is a little more, can be a little more involved than in regard to the abuse than the marital assets. It just really depends. Like if the person is abusing you, as you said, physically abusing or controlling, so that they can take marital assets and divert them, or maybe they're involved with someone else and they're using marital assets to fund that relationship while they are, suppressing you and mentally, controlling and causing you to have very low self-esteem or to be depressed or things like that. If you have, in those situations, I really strongly suggest you get a very aggressive attorney, because if that has happened to you, it's going to be very difficult for you to stand in the courtroom with that person, and you're not shielded and protected by a legal professional.
Very true.
I totally agree. We have a question here regarding divorce trials. Can you tell me why most divorces do not go to trial? Tanisha?
Yeah. One of the biggest reasons is money. It's extremely expensive to move forward with a divorce trial. The amount, when you start talking about the process of divorce, at least in the counties in Michigan, and I've practiced in a lot of counties throughout the state, only about 3% of divorces go to trial. And these are divorces that involve, normally high assets. Now, you may find some where, people are going to trial on principle because they are not going to allow the other parent to have joint custody, or how dare he want 4 overnights versus I want to give him the weekends, or, you know, however these issues are. So you have to be very, very mindful of the type of preparation that goes into divorce trials and with any trial. But divorce deals with a lot of discovery. So for the most part, you know, if you're dealing with custody or parenting time issues or financial, you got bank statements, you got exhibits, you're doing subpoenas, you need to prepare your witnesses for trial. That time, that money, is why most divorces don't go to trial. Because think of it this way, divorce is going to be probably one of the most difficult life transitions that you're going to go through. And not only are you going through an emotional transition, but you're going through a financial transition. You're going from a 2-income household to a 1-income household. And now you're going to take your assets from that one household that you are now subject to and utilize a large portion of that income or financials to pay an attorney to fight for what? It has to be something of value. If I'm not fighting for your $300,000 pension or 401k, might not be worth going to trial. If we're fighting about one overnight a week and I'm going to pay, you know, $20,000 to not give you that one overnight, you got to ask yourself, is it worth it? If we're fighting over the pots and pans, by the time you finish with talking to your attorney, you could have bought a whole nother set of pots and pans. So you really need to ask yourself, what it is am I fighting about? Is it worth it financially? Because at the end of the day, you're not dealing with a jury. Family court cases are decided by judges. And so one person who's going to come to the table with their own preconceived notions about what they think is proper for how your family should be functioning, what they think is proper as it relates to how the money needs to be divided, that's the one person who's going to make that call for you. So it's not about sometimes how aggressive, how great of an advocate your attorney might be. It's the judge who's going to make the final call, and you got to be prepared to deal with that decision. One of the questions that we always ask our clients during, you know, when we're entering a settlement agreement, Gwen, is if you had gone to trial, the court could have granted you the same, something more, or something less than what's in the settlement agreement. And that's absolutely correct. So you got to deal with what that risk might be. And some people are not prepared to take the risk, and that's why they don't go to trial. And all courts are going to require you to mediate. And so you're going to go through a lot of different channels to try to get some settlement before you even get to trial. If we're at trial, it's because for the most part, we got some people who are not going to agree about anything. And that's always difficult, and that's always going to be costly.
Absolutely. Absolutely. And, you know, with trial, there are situations where it's cost effective to go to trial. When I talk to my clients, I kind of do a financial, help them do a financial analysis to see if it's cost effective, you know, and like the example that you gave, if you're trying to get an extra $10,000 from a lump sum asset, if you're trying to get an extra $10,000 from a lump sum asset and you're going to pay me $18,000 to try to get that, you have to figure out if you want to do that. And sometimes they say yes. And sometimes they say no. I mean, and it's their choice. And you have to, as an attorney, we have to do it very delicately because, you know, I respect my clients' money. Everybody works hard for their income. And sometimes I've had a few, well, are you fighting for me or are you for me? Or, you know, which is really strange because I'm up here trying to, you know, protect your assets instead of, some people will say attorneys are just trying to line their pockets. So it's a very interesting dilemma. But on the other hand, there are situations where maybe you're trying to save what may appear to be a smaller amount of child support or spousal support or something like that. But over the years, when you do those numbers, it actually adds up depending on, like, if it's spousal support, it can add up, you know. You know, but I also tell, you know, when I go to trial, people are usually, my fees end up being for between $50,000 and $100,000, because by the time it's done, there's been a whole lot of discovery. There's been, you know, I don't just take the discovery that they give me through the interrogatories. I'm going to subpoena all your bank records. I'm going to subpoena everything. I'm going to do depositions, because I don't like to come to trial and have no idea how the other person is going to testify. I don't like surprises. And it also helps to let my client know what the weaknesses are. And at $345 an hour, you know, do you want to do that? And of course, I'm not going to just sit and give you a bill at the end. You're going to be giving me, you know, a $10,000, you know, retainer, or if we started out at a certain retainer, now it looks like we're going somewhere else. You're going to be, you know, and you know, we, as an attorney, you know, we don't want to have the position, well, we're only going to go to trial if you can pay this amount of money, but there's decisions that have to be made, and, you know, laying all that out to the client. And sometimes when it comes to custody, you know, sometimes it becomes personal. That extra overnight can be a big deal over time, you know, and the money part isn't the issue. It's the relationship building, you know, or fighting the fact that the other person is not agreeing because they're mad because I've moved on or something like that. So it's very personal. You know, going to trial is very personal, but extremely expensive. So people need to be ready to consider that big attorney bill that's coming.
Right. So we have a question that was at the beginning, but I'll end it with this question because we're almost at the 2-hour mark. We're at 1:46. So this is a question that, again, regarding parenting time. We said it at the beginning, and we'll just reiterate it here. How is parenting time handled during the shelter-in-place order? Do I have to honor the parenting time order if I think my child is in danger in another home at this time? Gwen?
You are supposed to comply with the current orders, because right now, unless there's an emergency motion and there's a basis for an emergency, then everything has to stay in place. But the key to part of the question here is, what is the danger? Because depending on the danger is going to determine if Child Protective Services is going to be involved. And right now, in the midst of this pandemic, the danger can potentially be the children being unnecessarily exposed to the COVID-19 virus. So it really, you know, is very dependent on what the danger is and how realistic that danger is, as to whether or not a parent should make the decision that I am not going to comply with a court order. Because when you don't comply with a judge's order, you better have a really good reason that you can back up. And like Kounsel TANISHA Davis mentioned at the beginning, you've got to be prepared for agreeing to, or being either agreeing or being ordered for make-up parenting time.
That's very correct. And just to kind of chime in, the point of what is the danger is extremely important, and to be attentive to what the history of these parties are. Meaning, if you are the parent who has decided that you do not want to comply with the shelter-in-place order and you're going to keep the child because, quote unquote, there's a danger in the other person's home, but when the judge looks at the docket and sees that you have denied the other parent parenting time on numerous occasions before, this is going to be looked at as some type of slight to try and utilize COVID-19 as a way to continue to deny the other party parenting time. So be careful about what is your history with allowing or denying or complying with the court's parenting time orders, because they're going to look at that. The other thing is, if you are going to deny or not comply with the shelter-in-place order and say that there's a danger in the other parent's home, say mom's husband has works at the hospital, and so he's exposed to, you know, COVID-19 patients, and I don't want my child going over there because that could potentially expose the child, and, you know, whatever the case may be. Then the proper way to handle that is, number one, document your communication with the other parent to say what your reasoning is and be ready to articulate that in front of a judge. Number two, document what kind of makeup parenting time you're going to offer that parent because of the shelter, you know, not being able to comply or not wanting to comply because you think the child's health and safety might be at risk. If you are able to do those things, you make it very clear to the court that, number one, you're not being intentional about trying to deny parenting time. And number two, you've taken your own kind of onus on this and saying, yes, I am going to not comply with the order, but I have given an alternative, and I'm going to give him the next 2 weeks as soon as the shelter in place is lifted. Or I'm going to give, you know, mom the next 2 weeks as soon as the shelter in place is lifted. Now you've taken the penalty kind of off of yourself because you've created your own remedy. And that's really what the court looks for in terms of parents being able to reasonably make decisions on their own. The courts don't really like to have to make decisions for your family. But if you force their hand, they're going to do it. And a lot of times they may not be what you want the court to do. And so it's much easier for you to kind of shape the ball and say, I'm going to give dad, you know, May 19th through June 1st. And that's going to make up what would have been his parenting time. Now, there's nothing for the court to be able to do because you have literally kind of stepped in and took responsibility for your own non-compliance. But I don't suggest it to be a habit because you also don't want the court seeing through games being played with parental alienation during a time that the country is going through something extremely difficult, and also the kids are going through something difficult. And I'm saying this from experience. I have a daughter who has a parenting time with dad, and he works in a plant which had been exposed to COVID-19. And I did exactly that. Got on the phone with them. Hey, listen, is there someone in your plant that's been affected, tested positive? What if we wait a couple of weeks? You can get her, you know, this particular day or this particular week. We've had no problems because I'm able to, I don't want to be standing in a courtroom trying to explain to a judge why myself as an officer of the court didn't comply with the court order. I'm going to do everything that I can to comply and some, because that's the position you don't want to be in, because you got to know that these judges are going to be dealing with these kind of complaints probably for the next 6 months, just because everything is behind. And after a while, they're going to get pissed. They're going to get angry that people are playing these kind of games. So if you have a valid reason for non-complying, then that's fine, because part of the statute says that you can deny parenting time when the child's health and safety is at risk. You have to be able to articulate the reasoning behind that. And it has to make sense. It has to make reasonable sense. And put the child first. Don't make this about your issue, the other spouse's issue. Think about the child, because their pattern, what they're used to, that's what they want. And that's what they're going to be looking for as well.
Absolutely. Absolutely. And
I totally agree.
To piggyback, I always ask my clients in regards to getting documentation to try as much as possible for it to be email.
Yes.
I know a lot of people text, I text and all of that, but you can lose some things in terms of trying to track the order of text messages,
yes,
depending on what kind of phone you have and how it sets things up. And when I have cases that the parents have a difficult time communicating, I always ask for communication to be through Family Wizard, because the judges are going to look at things a little bit differently when the communication is done through Family Wizard. Plus, you can document it, but document. In family law, document is king and queen, for darn near everything.
I totally agree with Gwen. I encourage all of my clients who cannot get along to use our Family Wizard, because not only does it help with tracking the communication, I actually get to see how my client is cutting up. So I can tell my client, I saw when you said this on this day, and you shouldn't have said this way, and this doesn't bode well in your favor. Or you have clients who will tell you that I'm only talking about the children with him, and then you see inside the wizard, oh, that's not all you've been talking about with him. You've been talking about other things, and that's why you have the problems that you have.
Yeah.
So I'm a advocate for that as well. Well, ladies, we are 5 minutes out. And so I want you guys to, again, state who you are and what you do and how you can be reached. And I'm going to start with you, Gwen.
Yes, I'm Gwen Davis Yancey, been practicing family law and estates and trusts for over 25 years. I can be reached at 248-358-6920. My combined website is Davis Yancey Strategy Centers. I'm an attorney and mind shift strategist, so I provide life coaching and help empower people to shift the way that they think, their mindsets and habits. I do anticipate, I've actually been offered a position as a referee for Wayne County Friend of the Court. So the other counsel for new cases, you can contact them. However, when it comes to being able to progress, either during your case or after your case, you can contact me because, like I said, I do life coaching and mind shift strategy coaching.
Thank you so much, Gwen. Tanisha, can you tell us about your practice as well and what you got on the horizon?
Yes, I am Tanisha Davis. I have a solo family law practice. I've been practicing for approximately 12 years. Actually, it'll be 12 years, May 8th. And I'm also a founder of a startup mobile app company called Kounsel Konnect that assists attorneys with scheduling conflicts. My practice consists primarily of high conflict divorces, custody and parenting time issues. I do some civil litigation as well, but lots of custody matters, change of domicile, moving out of state, that kind of thing. And I represent a lot of dads. And I can be reached at my email, the tanishadavislawgroup @gmail.com. My website is currently being revamped as we speak. And I can also be reached at my office, 248-996-8701.
Thank you so much, Tanisha. I just want to say that I am appreciative of both of you ladies for joining me. I am Chandrika Simmons, also known as the Law Chick. I have a civil litigation practice here in Oakland County. I go all over the state. My number at my office is 248-732-7559. I see a couple of you have been utilizing that because my office has been ringing and it hasn't rung in many, many weeks. So I appreciate the calls that are coming through right now. And I also have, you're able to make appointments with me on my website at lawchic.com. And as of right now, all my appointments will be via the phone or virtually. So keep that in mind. I'm not allowing clients into my office at this time, but I encourage you to reach out to me. I do labor and employment law, family law, probate law, and contractual law. I also used to be a union lawyer. So I'm very well versed with collective bargaining agreements. So if you have issues and questions regarding that, issues regarding your seniority and your pension issues on the job, I'm here for that as well. And I thank you ladies for joining me, and I appreciate you being a member of the Black Women Lawyers Association. And we appreciate the Black Women Lawyers Association of Michigan for allowing us to reach our potential clients via this platform. Thank you so much. This is a conclusion for the People's Law School. Thank you, ladies.
Thank you for having us, Chandrika.
It was awesome.
You guys have a good rest of the day.
You too.
Do we just log off?